So for those of you on, again, I appreciate you jumping on. For those of you who I haven't met before, my name's Quinten Cupps. I'm an attorney with Weil Fotheringham, and I'm excited to present this class this year because I think for the first time in many years, we actually have a lot to talk about today. The goal today will be to go over the recent changes in the law from this legislative session. We're going to focus on the bills that have actually been signed by our governor. And I will make mention towards the end of some of the bills that didn't make it to the governor's desk, but I fully expect some, if not all of them, to try to be reintroduced next session. So I think it's good to talk about those just so you might have an idea of what to expect for next session. We'll also have a discussion at the end as well on some of the case law. There's not very much to talk about, but just some of the cases that to be aware of that are pending right now in some of the courts. So just so you know, for those of you who might be interested in this, this has been accepted as credit for the continuing education for CAI. So there will be a code that I mentioned later in the presentation that you'll need to remember for that credit. And after the presentation, you can reach out to Terry, and she can provide you with that certificate for those of you who might need that. I know this is not ideal being on Zoom for some of you, and for me especially, I prefer teaching in person, just because I think it fosters more communication and more interaction. I would ask that you stay on mute while I'm talking, but please do not hesitate to interrupt me if you have a question. You can put it in the chat box, which we'll monitor, or you can just jump in and ask me a question. I'm perfectly okay with that, and I think that helps everyone to learn more. I imagine some of you have probably been to other presentations that have been done by other law firms or other organizations, and so feel free to share insight or thoughts on what you may have learned. I'm not going to pretend that I know all the right answers on this. I think whenever it comes to legislation, there is some interpretation. Now, I did have the privilege of serving, and don't worry about the screen. That wasn't intended to be read yet. That was just kind of a back filler. So in fact, you know what? Let me just get off this screen. I'll go back up to this screen. That was just a graphic. So I had the privilege of serving as a co-chair of the Legislative Action Committee for CAI this year. This is my second, I think, session in doing this. So I have a little bit of insight into kind of what went into some of these bills that we fought and tried to make better than what they were and introduce, and we'll talk about that as we go forward. Tara, any luck on that document?
Yeah, give me just a second. I'm uploading it to my OneDrive.
Okay. All right. Well, when you get that, just interrupt me and let everyone know where it's going to be.
Well, I'm going to set it in the chat here in just a sec.
Okay. All right. So to get started, I didn't really put these bills in a particular order of importance, but I did leave some of the juicier bills that I think are going to affect associations more. I put those towards the end. There are 6 bills that as part of CAI we were tracking. I think they are relevant to associations. 6 of these bills have been signed by the governor now. 2 of them were just signed a couple days ago, and that's why I didn't have this chart to you sooner. I had to update it this week because I was informed that the 2 of these bills that were just kind of hanging around had been signed. So just kind of a brief overview of this session. I will first start out by saying that the session is not over. Okay, they have not ended. They have not adjourned the session. They are still bickering about certain items, and it's kind of a tit for tat between the governor and then the House is controlled by Republicans, and they're going back and forth with each other on things, and it's dragging out the session. We don't know when it's going to end. We believe that there's a chance it could end at the end of this month, that they could adjourn. But if the games continue, this could drag on for months, and it could go into September, October, even the end of the year. Now they'd have to adjourn by the end of the year, but It's still dragging out. The reason that is important, as some of you might know, is that all these bills we're going to talk about, they do not go into effect until 90 days after the session ends. That's the sine die that you might have heard before. So these bills have been signed and we need to talk about them, but they won't go into effect until 90 days from a date that's unknown right now. So kind of to be continued, to be determined later on when we actually really have to start worrying about the bills and doing anything about them. As you can see there, and this number is not exact because it has changed a little bit, but there were a little over 1,600 bills that were introduced this year and tried to make their way through the process. 158 bills were signed, and in what was a record for a governor, 111 bills have been vetoed. And that I read some articles that did set a record for an Arizona governor. So our governor was very active this year in vetoing the bills that were presented to her. And it was surprising. If you look at those numbers, you wouldn't think that we had many bills to talk about, but we did get these bills that came out of the session. I'm going to throw out throughout this presentation numbers of the bills, either Senate bill or House bill. This website that I have on the bottom, I'm sure a lot of you are familiar with it, but if you go there and there's a little heading that says bills, you put your mouse over that and a little drop down box will come up and it will say bill tracking. You can go to that website, type in the number of the bill, and you can see everything about the bill, the history of it, the amendments that were introduced, the final version that was signed, or maybe it never made it that far. So I just want to make sure you're aware of that website. Still no chart, Terry? All right.
No, I'm having difficulty. If anybody knows how to do it, I used to be able just to drop it in there, but now it's only giving me access to do it via certain programs like Dropbox, OneDrive, Google Drive, and SharePoint. All these things I don't have.
Terry, it's Christina. Email it to me. I did it a couple days ago.
Okay.
I'll get it in there.
Thank you.
And if we keep having trouble with it, I'll have Terry email it to each one of you. All right, so let's get into these bills here. These are the 6 bills on the screen here that have been signed that we believe have some relevance, some more than others, as I said. And then there will be some other bills we'll talk about when we are done with this first discussion here. So the first bill that was on our list that we were tracking was this residential picketing bill. I'm not going to spend very much time on this because this is not going to be a bill that you probably ever have to worry about. But there were some changes to this is a criminal statute. It's ARS 13-2909 is the statute that was revised here. There's a crime that prohibits residential picketing is what it's referred to as. And they expanded that definition, and that's why I think it's important, because it talks about any picketing or demonstrating that takes place in front of someone's home. And then there's some conditions that picketing is intentionally directed at the person who resides in the home, and that person in the home would find that activity to be harassing, threatening, or alarming. So it's kind of like the same sort of standard as an injunction against harassment. I don't know how many of you have homeowners that have the time to go picket in front of other homeowners' homes. So you may not see this, but it could be a situation where you might have a nuisance in your community, what you might think is an owner-to-owner dispute. Association may somehow get dragged into it. Now, you obviously aren't the law enforcement as an association, but calls could be made, actions could possibly be taken to try to address that type of activity. So just to be aware of it. And that is all I'm going to spend on that bill. Senate Bill 1049. For whatever reason, the legislators, this is the second year in a row now that the legislators have felt the need to get involved and mess with the statute that deals with flags in our communities. Last year, you'll remember there was the first responder flags that were introduced as the 7th flag on that list of protected flags. During that conversation last year, there were many legislators that it actually was a very heated discussion. There were many legislators that wanted to just get rid of any prohibition on flags and just say, you know what, associations, you can't, if someone wants to put up a flag, I don't care what the flag says, they get to have it. And that didn't make it out as any sort of bill, but that was the discussion. I believe this was Senator, I can't remember who the senator was on this one. It might have been Kavanaugh, but he came to the table with this bill to introduce a new flag that associations are not allowed to restrict against. And it's referred to as the Betsy Ross flag bill, because that name is in the statute. But I think it's important to know what the language says in the bill. And what it says is that the way they describe this 8th flag on the bill that you can't touch, it refers to as an historic version of the American flag, including the Betsy Ross flag, without regard to how the stars and stripes are arranged on the flag. That's the language that you're going to see in the statute. So it goes on to define what a Betsy Ross flag, which you can see on the screen, that is the Betsy Ross flag that you're all very probably familiar with. But I think the important part of that statute is the other language that was inserted in there. That while we can't touch a Betsy Ross flag, you have to be careful that there could be any other variation of an historic flag, regardless of how the stars and stripes are arranged. So this does, I think, open the door, kind of like the first responder flag last year, flag bill, where you have all types of variations of colors and symbols and messages that could be considered a first responder flag. There could be variations of this flag that, as an association, you're going to have to be careful with. If you see a flag go up that you think is not protected, just make sure that you look at it and consider what this bill says, or what the statute will now say regarding this type of historic American flag. So that's that. Any questions on that bill? Okay. So House Bill 2301. This, I'm a little cynical when it comes to some of these bills, because and for those of you who have ever experienced or been involved in this process, many times, and I think more than often than not, a legislator will receive a phone call from one individual, and that individual will be complaining about a particular issue in his or her community. And the legislator will then convert that into a statewide problem of statewide importance that has to be addressed through a bill. And that's how a lot of these bills come into play. This is one of them. Okay, there was an individual who felt that the stats, as you know, this is for let me give you the citation to the statute. It's 33-1808, which is the Planned Communities Act, or 33-1261, which, if you're in a condominium, that would be the provision for the Condominium Act. In both of those statutes, it's word for word the same. Currently, the statute says that associations can prohibit, and I'm paraphrasing here, but essentially you can prohibit door-to-door political activity if you're in a gated community. Okay, if you don't live in a gated community, you can't restrict that type of activity, with some exceptions on time and place kind of thing. There was this individual who believed that this was infringing on people's rights, that associations were interpreting this statute too broadly to prohibit people from coming into the community when you shouldn't be, and felt the need to try to revise this bill. So there was a change made, and in the current statute right now, in both of those statutes, there's subsection D, is where a lot of the language is, and there's subsection I, which subsection I is that conditional language that exempts gated communities. The way subsection I is currently written, I think, has been interpreted by some attorneys in our industry a little more broadly than maybe it should have been. And I think that's led to some of the confusion. So what they did is they got rid of subsection I and they combined everything into a new subsection D. And I think it might be a different subsection in the Planned Communities Act, but it's all in one paragraph now. And essentially what it now is going to say is that the association still cannot prohibit door-to-door political activity in the community. That type of activity includes soliciting support or opposition regarding certain candidates or potential ballot issues. Okay, the association can't tell someone no if as it currently stands, but there are 3 exceptions now. Okay, one is you can have restrictions that prohibit this activity between sunset and sunrise. So during the night, you can state, you can have a rule in place that says none of that activity can take place during those hours. You can also require that there's a prominent display of an ID tag for each person that's engaged in that activity, along with a prominent ID of the candidate at issue or the ballot measure at issue. So you can require that be on full display so that it's very clear what these individuals are doing. Now, the new addition to the statute, to that section of the statute, says that you, if you are in a gated community, essentially you cannot prohibit anyone if they are accompanied by an owner or a resident of a unit or a home. Okay, if that person is accompanied by an owner or a resident, they are allowed to come into your community even if you are gated for this political door-to-door activity. But if they are not accompanied, you can still prohibit the entrance of those individuals for that type of activity. So that's kind of the slight variation on the way the statute used to be written, is it all turns now on if whether or not they're accompanied by an owner of the community or a resident of the community. So just for those of you in gated communities, just be aware of that new restriction on enforcement against this type of activity. Now that's not an issue that I hear a lot of as far as associations being concerned about. It comes up every 4 years, right? So just be aware that that is how the law is going to read once it finally goes into effect. All right, any questions on that bill? Okay, the next bill. Okay, this is House Bill 2607. This, I'm just referring to it as the board removal statute. I think there's a different title on the page. It's a little more vague. So I'm just referring to it as a board removal statute. Let me just give you a little history on this bill. If you remember, I think it was six or 7 years ago. As you all know, there's a statute in both the Planned Communities Act and the Condominium Act that governs the removal of board members. If you have a member of your board, or if you are a member of the board, and someone is trying to remove you from office and not waiting until the next election, they have a right to do that. But there's a statutory process that has to be followed to the letter. Okay, you don't look at your bylaws, you don't look at your articles, you don't look at the Nonprofit Act. Okay, everything is governed by these statutes in the Planned Communities Act or the Condominium Act. And there's a requirement, I'll just go over this quickly here. There's a requirement that a petition be signed by a certain percentage or a certain number of owners in your community. It depends on how big your community is. And that number is dictated by the number of homes. That petition is then signed by that certain percentage. And I believe it's 25%, unless you're a community of over 1,000, then it drops to 10%. And then there's some numbers that go with it. But essentially, the number of people who are eligible to vote will sign this petition and submit it to the board, saying we want so-and-so or all of the board, we want everyone removed. Once you receive that petition under the current statute, the board has 30 days to call a meeting, to notice a meeting, and to hold a meeting. Where a vote will be taken as to whether or not the members that are on that petition are removed as members of the board. 6 or 7 years ago, the bill said what it said. That part hasn't changed much or at all. But 6 or 7 years ago, there was a community that tried to remove members of their board. They mistakenly only put 4 out of the 5 board members on the petition. The 4 of them were easily removed. It was very contentious, but there were plenty of people who wanted to vote to remove them. However, the 5th member wasn't on the petition and wasn't removed. Well, that 5th member of the board, using the language in the bylaws that allows for vacancies to be filled by appointment of the remaining board members, proceeded to appoint members of the board that had just been removed back onto the board. It wasn't against the law at the time, but that led to a change in the statute from 6 or 7 years ago, where it inserted language to say that if you're removed from the board, you're not eligible to serve on the board until your previous term expires. So that kind of buttoned that up. Well, fast forward now 6 years later, we have another issue that's come up where an association, a group of owners, feels the need to remove the board. They don't think that the board is going to comply with the statute. And so they take it upon themselves to schedule a meeting of the members and hold their own board meeting removal board removal meeting. The problem with that action is that the statute is very clear on how this process is to take place, and that the petition is supposed to go to the board and the board is supposed to call the meeting. The owners don't get to call this meeting. So in an effort to, so this led to a very heated introduction of this bill and a discussion, and her last name is Parker, Representative Parker, introduced this bill to try to address this for her constituents. And there was a different variation of the bill that was first introduced. And that would have allowed homeowners to call their own meeting for this. There were objections to that version of the bill. It didn't have the intended consequences that I think she believed it did. And so a different variation was then adopted. And that led to what was then signed, what has been signed by the governor. So this is for ARS 33-1813 if you're in a planned community, or ARS 33-1243 if you live in a condominium. And I'll just stop real quick. The chart that I put together was emailed to everyone. And if you look in the chat box, there's a link to a Dropbox. Thank you, Christina, for putting that Dropbox together. You can click on that and pull up the chart and follow along. The intention of the chart is not to give, any sort of formal legal opinions on the statute. It's just to summarize what the statutes say. But it's a little quick reference guide for those of you who might, forget what I tell you over this next hour as soon as you log off. It's a quick reference guide for the future. All right, so the bill that was introduced and that's now been signed made one small change to the statute. It inserted one additional subsection. And what it says now is that if the board receives a petition from its members that has been signed by the requisite number of owners who are eligible to vote, and then if the board fails to notice and hold a meeting within 30 days of receipt of that petition, that's the current requirement. You have 30 days to hold this meeting. If you fail to call, notice, and hold that meeting within 30 days, effective at midnight on the 31st day, the entire board is removed by operation of law. The entire board is gone. Now that's going to create a whole separate scenario of what do we do now? We don't have a board in place. If you scroll down a little further in that statute, there is a provision that I think that would be looked at, is that it says that if the entire board is removed, then an election must be held within, I think it says another 30 days or something like that, where you hold an election and elect a new board. I think you would default to that if your whole board was removed. But it is going to create a scenario where managers are in a position of what do we do? We don't have a board to take direction from. Who calls the meeting? How is it officiated? Those types of things weren't addressed. And the problem with this bill is that this representative refused to have any conversations with anyone. She's a new representative. She was just elected recently. And she kind of took I'm going to take my ball and go home mentality. She introduced the bill, wouldn't meet with anyone, wouldn't entertain any real issues, and just pushed it forward. And that's, I think, as a representative, we're going to have to keep our eye on for next year, because she has HOAs in her target, in her site. But so for the takeaway for this bill is that if you receive a petition for the removal of your board, please act immediately. Don't sit on it. Get your manager on the phone, get your attorney on the phone, and figure out what needs to be done. Now, there are ways to defeat the petitions. If the requisite number of signatures are not on there, then it's no good. One common mistake I see owners make is that they will get tenants to sign the petition or non-members to sign the petition, and those don't count. So there is a way. There is a way to defeat those. Now, there is a question of saying that all directors removed or just those listed on the petition. That's a good question, Tracy. The way it's not clear in the way it was written. I will tell you from the intent of the statute from the person who put this together, the intent was to remove everyone. Now it just says the members shall be removed. So maybe there's a way to interpret it to say only those members on the petition, but I can tell you the legislative intent of the bill was to have everyone removed from the board. So that might be something that gets sorted out and litigated later because it wasn't as clearly written. But again, that goes to the problem with the bill, that we weren't allowed to give any feedback on the language. You know, we would have, those are the types of things we would have tried to clarify, but they pushed it through with the language that's in there. So it's meant to be a punishment to the current board, that you're not doing what you should be doing, therefore you're gone. We're going to start over. That's how they looked at it. That's how they considered it. And it's unfortunate because it could end up punishing those board members who are there to do the right thing, and they get wrapped up in this. So we'll see what comes of that, if any changes are made next year, or if someone tries to litigate that issue. But that's the way it's written. All right. So the members is Representative Parker is her last name, and her first name is escaping me right now. It might come to me, but her last name is Parker. She's from the district. She's in Mesa is her district. I don't remember which district number it is. All right, next bill. We'll move on to the next one here. This is a bill that was just signed, I think a week ago. The governor signed it. This is one that had been floating around for months now. It was introduced along with all the other bills. It's gone through different variations. This bill was started. There were insurance companies that were trying to find ways that they could protect their bottom line and try to get language introduced to help protect them, because they were really suffering from claims being made in condominiums. Now, this bill only applies to condominiums, so there's nothing to worry about if you're in a planned community. In the chat, you'll see, Barbara Parker. That's it. Thank you, Amanda. That's helpful. There was another representative who I think lived in the community where this was taking place that was involved. I think it was last name was Heap, maybe, but Representative Parker was the one who introduced that removal bill. Okay, so House Bill 2251. This is a revision to ARS 33-1253. For those of you who manage or on the board of a condo, you know that 33-1253 is the lengthy section. It's one of the longer sections in the Condominium Act that governs your insurance. It governs your insurance policies, your coverage, claims issues. It covers all of that. It covers, the money held for repairs, things like that. The people behind this bill came to the table months ago to say, hey, we need to do something about these claims. We're going to introduce some language that the first iteration of this bill actually had language in it that said, if you live in a condominium, the condominium association will be required to have an insurance policy that covers the condominium, the common elements, but is also required to insure all units, regardless of what your documents say. That was the first attempt at this bill. They were going to require every condo to insure every unit. And those of you involved in condos, you can probably see right away what a problem that would be. You have some of these older condos, they're not going to have the money to get a policy that would insure the units if you don't already insure them. Now, some communities are already required to insure the units, and you would just continue to do that. Nothing's going to change there. But thankfully, we were able to work with some people and get through CAI. We were able to get some of this language changed to take out that requirement of insuring the units. That was one of our biggest concerns. But some of the changes that you need to be aware of include, it does have reference to insuring the units, but it does have the condition that only if your documents require it. So that's going to require every condominium to carefully review your CC&Rs, talk to your insurance broker to see if there's a requirement for insurance on the units. If there is, you're required to have it. One of the interesting changes, though, that came from that is that there is language now that says that owners will have the right to report a loss on the master insurance policy. As it stands right now, that language isn't in the statute, and there isn't a right that an owner has to just make a claim. Usually, you'll have a process in place where the owner will report to the manager or the board and say, "Hey, I need to file a claim," or here's the issue, please file a claim, and you go through that process. Now there's this system in place where the owner is going to be allowed to file their own report their own loss. Now, this will depend obviously on what the policy covers as to whether the loss, if you don't insure the units, then you're not going to file a claim on the policy for the unit for the loss. But depending on what your policy says, there's going to be an avenue now for owners to file claims. Now, before they report that loss, though, the one thing we were able to carve in there to help alleviate some of this issue is that owners are going to, before they report a loss, they do have to notify the association ahead of time, and the association will have 10 business days to review the request and to make a decision on whether or not a claim is going to be filed on the policy. And then within those 10 days, they have to provide the owner with a written response explaining their decision on if they decide not to file a claim. So there might be reasons why a claim wouldn't be filed. Maybe the claim doesn't exceed the deductible. So you're not going to file a claim if it's not over the deductible. There might be other reasons. That type of analysis and discussion, if you get those claims, you really should talk to, loop in the insurance broker, loop in the attorney for your community, make sure you're on the right page there and in the right position to deny a claim, the reporting of a claim. But just know that owners will come to the association now and say, "Hey, I want to report a loss." You have 10 business days. Okay, don't include weekends or holidays. It's 10 business days to provide them with that response to comply with the statute, and then go from there. The other requirement that every association is going to have now is that every year, this is condominiums again, every year the condominium is required, it will be required now to inform their owners in writing of two things. You're going to have to notify your owners of their responsibility for any responsibility they might have for the association's insurance deductible or any policy that applies, and then the amount of each deductible. So you're going to have to give notice every year to your owners, and maybe this coincides with your renewing your insurance policies or obtaining a new policy. You're going to have to send out that written notice to every owner, providing them with that required information. So here's a question. Can we simply respond with "Your claim has been tendered to insurance," and let the insurance carrier determine if it's a covered event? I think you could, because the requirement is that you just have to report the claim to the policy, right? And so if you report it, and then they decide that it's no good, then you've met your requirement of informing them, and then I think you would inform the owners that you've tendered it to the insurance and that a decision will be made. So that's a good question, Tracy, and I think that's how you can handle that. Written notice or electronic is another question. Now it just says in writing, so I think electronic notice would be okay. It doesn't say that the written notice has to be mailed, to the last known address. It just says written notice has to be provided. So I think emails would be okay if you have the current email address for your owner. If you don't have an email address, you're going to have to send a letter. So yeah, that's another good question, John. Just some form of writing, you have to provide them with that information. So there are some additional clarifications. If you go onto the bill tracking website and look at the version of the bill that was signed, you'll see some other small grammatical changes. There's also in one of the sections, it talks about what the association's policy, whatever that policy is, it has to include liability coverage and property damage coverage. They inserted the word property damage after. Right now, it just says liability. So that might be something too, where once this goes into place, is in effect, our recommendation to every condominium is to immediately talk with your broker and see what changes might have to be made to your policies, or what you need to do to make sure you're in compliance with this statute. And if you need to loop your attorney and do that as well. But just know if you're in a condominium, there have been changes to the insurance requirements, and And as soon as the session ends, you'll have kind of a 90-day countdown before it goes into effect. All right, any questions on that? Hopefully you guys all received the chart or you were able to access it through that link. I mean, you can kind of follow along. Everything that I have said for the most part is on that chart. All right, the last bill here, and this is I think probably the juiciest one because I think it's going to affect probably the most communities in the state. For those of you who have been doing this long enough, you know that parking and roadway issues this is not the first time that this issue is brought to the table. It seems like every year there's someone out there who wants to do something about parking on the streets, or an association's ability to do something about their parking restrictions. And there was a revision back in 2015 that introduced, it's ARS 331818 is the statute that applies here. Back then, there was kind of this grandfather language that was put into place that said any community where the declaration was recorded after December 31 of 2014 is no longer allowed to enforce or to regulate public roadways, is the way it's written. And so that essentially means that any community that was created or declarations were recorded after that date, if you have restrictions in your CC&Rs that govern the public roadways, mainly parking restrictions, those newer communities are not allowed to enforce that. It goes back to the cities to enforce. All the older communities prior to that 2014 cutoff date, I should say prior to January 1st of 2015, really, you still have the ability to enforce parking. Well, this is another example of a bill that came to be because of a representative. This one's a little different because the representative was concerned about his own community and wanted to try to address the parking issue in the community. And the first iteration of the bill was to just say, you know what? I mean, when we first met with this representative, the intent was, we're done with parking on public streets. We're going to write a bill. This bill is going to say, no matter what your documents say, you can no longer enforce any parking restrictions on the public streets. That was the original intent of the bill. That was quickly met with objections and remarks to say, well, look, if you do that, you're going to have some of these cities that are going to be all up in arms. We're not about to start trying to enforce parking everywhere. I don't think your bill is going to be successful. And so that led to an amendment and some additional language. And it ultimately led to this bill that is in front of us. Now, this is not a bill that I think anyone in the industry was really happy with, but it was going to go through no matter what. There was no objections really to it. And it was just a matter of what's the best language that we can put forth for this. So I want to go through this bill in a little more detail. And I've already received some questions from clients about what this all means. And I'm still trying to digest some of it, of what it might mean for legal opinions and legal rights for the communities. But essentially, the first thing to know is in both paragraphs, so there's two paragraphs, actually there should be three, but there's two main paragraphs of what this statute will look like. Both provisions first have qualifying language that says after declarant control. So if you're in a community that's still controlled by the declarant, the statute does not apply to you. Okay, a declarant can do what the declarant's going to do until it turns over to the association. So I just say that first, just for those of you who might still be declarant controlled. That period of declarant control is the phrase. So what they did is they kept the same date, that date that I just mentioned. Okay, so any declaration that's recorded after December 31st of 2014, okay, nothing changes. You still cannot restrict and regulate public roadways in your community. Okay, that status quo for those newer communities. As a bit of a tangent here, let me just say, there are questions that often come up of what does that mean when it says if the declaration was recorded. So what if you're in a community that was formed in 2017? Or no, let's say you're in a community formed in 2012, but you go to amend your CC&Rs. Let's say you amended your CC&Rs in 2018, so after that date. I don't know if you've received legal opinions, but there's a question out there that I think some attorneys differ on of what does that mean to record the declaration? Do you have to do an amended and restated declaration to then trigger that parking provision? Or what if you just amend your CC&Rs to change the assessment language? Okay, you have nothing to do with parking. Okay, does the parking restriction still carry over to that with that new amendment? and you still are able to enforce, even though the amendment was recorded after this December 31st, 2014 cutoff. Many times I've given the opinion of just that if your amendment doesn't touch the parking language, you can still enforce the parking. However, there have been some arguments raised recently by some of the owner attorneys that I've heard that it's kind of an interesting argument. If you look at the definition of a declaration in the Planned Communities Act, go to the first section where there are definitions. Okay, the declaration is defined to include amendments. And so the argument is, well, it's defined as the CC&Rs plus any amendments. Therefore, any amendments you did is part of the quote unquote declaration as it's defined. Therefore, your declaration was recorded after December 31st of 2014. And if you did that, you can no longer enforce parking on public streets. So I haven't seen that litigated, and I don't know what the court would say on that, but I just wanted to throw that out there because I hear that question all the time. But just know, so going back to what I was saying, the cutoff is still the same date for applicability of this statute. It goes on to say that if your declaration was recorded prior to January 21st, 2015, you can still regulate public roadways, but you now have a cutoff date that's been established. Okay, this ability to regulate public roadways will continue for you until June 30th of 2025. Okay, that is the hard cutoff date. After June 30th, 2025, if you have not done what we're about to talk about, any restriction in your CC&Rs that governs public roadways or that deals with public roadways is out the window. It will be void. It will be unenforceable. Okay, and so I keep saying enforcing public roadways because that's the language in the statute. The statute doesn't say parking. Okay, it says regulating public roadways. Now, most of the time, I think almost every time, that's going to involve any sort of restriction or rule that deals with parking, because what else do you do on the streets? But I just want to make sure we're clear. This is not a parking statute. This is a regulating public roadway. So any violation that might take place on a public roadway could be at issue here with this statute. So back to that date, June 30th, 2025. That's your cutoff date. Now, what's been carved into this statute is the ability of any planned community, and again, this is just planned communities, any planned community that has public roadways, if they want to continue to enforce or regulate the public roadways through whatever's in their CC&Rs or whatever's in their rules, they're going to have the right to do it if they're going to give the right to the owners to make that decision, essentially. Okay, you're going to have an opportunity to call a meeting of your owners and give them a chance to vote in favor or against regulating public roadways. And that's the way the statute's written. It says a meeting of the member is noticed and held on the question of whether to continue to regulate public roadways. So it's not a ballot to go out to say we're going to vote on whether to keep enforcing parking. You need to be clear and careful on this, but you have this opportunity to and Jen, I'll answer your question here in a minute. If you're going to have this opportunity to save whatever provisions you have in your documents that deal with the public roadways. Now, again, like I said, most of the time, if not every time, it's just going to be the use restriction sections that deal with parking. Okay, but the vote to the owners is whether or not, this is the way I think it is, it's whether or not we're going to continue to regulate the public roadways. Now, you may get specific and specifically reference certain provisions, but the overall vote is to continue that ability to regulate these roads through whatever means are afforded us in the documents. So the meeting, though, just let's just talk about how the meeting is held. It's just like any other meeting of the members. Okay, just like your annual meeting. Okay, a notice is going to have to go out by mail to the owners, just like you would an annual meeting. It has to be held within 10 to 50 days of the notice, just like an annual meeting. Where it differs, well, actually, the quorum requirement, there's no quorum mentioned in the statute. You're going to default to what your documents are. If your documents are silent, the Nonprofit Act says 10%. So you use the same quorum requirement as you would your annual meeting. Where it differs at that point is when you send out the ballot. Okay, you're asking for, you send out the absentee ballot, you make a ballot available at the meeting where you're going to hold it. People will have an opportunity to vote. Whether or not this is approved is a majority vote of those voting at the meeting. Okay, it's not a majority of your whole community. Okay, it's a majority of those votes you get back and that are cast at the meeting. So you total up all those votes that you get for the meeting, and it's a simple majority. And if that simple majority is achieved, then your rights to regulate public roadways will continue beyond the June 30th, 2025 date. If that happens, if you hold that meeting, you cast the vote and you're successful, then you have to record a document with the county where you're located, basically stating as much. You know, a meeting was held on this date, majority vote, it passed. This association will continue to regulate public roadways, something to that effect. The statute goes on to say two things. If you fail to hold the vote, right? If you never hold this meeting that we're talking about, or if when you do hold the vote, it is unsuccessful, then you're done, okay? It fails, that attempt fails. You now fall into that camp of those who just ignore it. The June 30th date comes, it goes, you can no longer enforce public parking or regulate the public roadways in your community. So it doesn't fail. The question that I received is if the vote fails or no vote is held by June 30th, does this not mean that the authority would expire immediately upon a failed vote? So let's say you go out in 90 days after the bill is put into effect and you just hold a vote right away. That's a great question, Jen. And that now that I'm thinking about it, that wasn't discussed in as we discussed this language. I think there's an argument that it would continue until the June 30th, 2025, because the way the statute is written is it says you have up until that date and it will expire unless one of the following things happens. But I have to look at that again and see if it could be interpreted the other way. But with that question, though, I think the thing to look at is, one, there's some rumblings. I've heard some rumblings about there might be people who want to look at the statute again next year and maybe reconsider some things, because think about the implications of this bill statewide. Okay. If you have a bunch of associations that decide, you know what, we're not going to touch this. We don't care. We don't want to enforce parking. Well, who's going to enforce parking now? Okay. It just defaults back to the cities. The cities are all for associations because it takes away from them the responsibilities to do all kinds of things, including parking. Okay. Are they prepared to now have to start enforcing parking in hundreds of communities that they didn't touch before? So I think there might be an attempt to look at this again next year. So one thought you might have, or what thing you might consider doing, is once this goes into effect in 90 days from whenever we end, don't rush out and do the vote, right? You have until June 30th, 2025, and it's a one-shot attempt, right? You try this once, then it either passes or it doesn't. Let's see if maybe wait to see what happens in the next legislative session to see if there's going to be another attempt to revise this bill or this statute. And if there's not, then maybe, this time next year you're holding the vote. Just something to consider. Question here. Let's see. I think I saw a couple questions here. Let's see. If you try to hold the meeting and you don't make the quorum, are we required to continue to try to hold this meeting until valid? Well, first, you're not required to hold the meeting, right? I mean, unless you want to continue to enforce the roadways. But so the question is going to be is if you don't make quorum, is the vote unsuccessful? And that's another issue that wasn't fully addressed. I would say there's a good argument that if you don't hold the meeting, then you haven't had a successful or an unsuccessful vote. You could try again, and if you get quorum, I think there's a good argument for that you can try until you get quorum. But there might be the counter to that to say that if you try, that's considered a failed vote because you couldn't get quorum. So I'm throwing out the good it depends or maybe kind of response from the attorney here. But Tracy, that's a good question there, and probably have to look at that a little more closely with the language. Another question: if you hold the vote in 2024 and parking restrictions are voted down, and a year later homeowners are fed up and they want another vote, can you hold a second vote? And I would say the answer to that is no. The statute's very clear that if you hold a vote and it fails, then your restrictions are done. Now, when they're done is the question that was asked before. Is it done effective immediately, or do you wait till the June 30th? That I think we need to sort out still, but you only get one bite at the apple here. And then another question, do you think a court will uphold this if it's challenged, since it has already basically stated that the communities need to agree to any changes to the CC&Rs? So the great question, Lisa. It brings in that Callaway case, what we talked about at ad nauseum last year, and amendments to the documents. I don't know. I'll just be honest. I really don't know if it would be upheld or not. I don't know if there is I mean, there might be a constitutional challenge that it's interfering with contracts. Maybe that comes up as an issue, and maybe Callaway's roped into that as well. That's a good question. Let's see. Is it allowed to not hold a meeting, only vote by absentee ballot? If yes, absentee ballots, who writes minutes and counts the ballots? The statute specifically requires a meeting. It says that you're supposed to hold a meeting, and where a vote will take place. So now, one question that might come from that's maybe along the same lines as Rebecca's question is, there's the Nonprofit Act statute that talks about actions being done by written ballot or without a meeting. So there might be a way using the Nonprofit Act to avoid having a meeting. And then the board, I think, would kind of fall into the place of having to count the ballots and do any minutes and eventually, recording that document that you have to record if you get enough yes votes. So I love the questions, because this highlights the issue many times with these bills, is that they're not written typically by they're very rarely written by an HOA attorney. Sometimes they're edited by one, but there's only so much we are able to do to try to make changes, and there are always issues that come up with the language that's used. So I think a lot of this will just have to kind of be flushed out with your attorney for your community. And as the board, I think for right now, like I said, it could be a kind of wait and see approach. But if the board is really anxious about holding that vote, you'll want to talk to your attorney and kind of walk through the process and make sure all the T's are crossed and the I's are dotted. An absentee ballot would count as present for purposes of the meeting, wouldn't it? An absentee ballot would. I mean, that is the whole idea of an absentee ballot, is it's as if you were there. But the statute does say that you need to hold a meeting, which would then trigger 33-18-12, which requires absentee ballots and giving them an opportunity to vote in person at the meeting. So that's just my concern with that. Is I think you are going to end up triggering some other statutes in the Planned Communities Act to make this go through. So again, there's a lot of, we'll see what happens, but just know if you live in a community or you manage a community that has public roads and you have restrictions that deal with the public roads, you're going to need to, the board's going to need to make a decision and maybe get the input from the owners, whether or not this is something that has a chance of being successful. Do people really care? Maybe people don't want to continue to have to worry about parking. I mean, I've had clients in the past where, big communities that have public roads and enforcing parking on the streets is impossible. Trying to match up cars to homes and who the owner of the car is. And I've had some communities that have just started to kind of take a hands-off approach. And in one community in particular, they received a letter from an owner threatening to sue them for not enforcing their parking provisions. So, I mean, you might have communities like that where you have one or two owners that are very anxious and excited about and feel that you need to enforce parking, even if the board doesn't want to. So those are types of issues you're going to have to take into consideration as a board in deciding how you want to handle this statute if it applies to you. So, all right. Just real quick, let me give you that code that you'll have to give to Terry for those of you who need the credit. The code is BILLS, BILLS, BILLS. So you can give that to So there's a comment from Jen here. At the hearing on the bill, the sponsor testified that the effect of public parking was to prevent owners from parking on the street, but not the public. Well, that might have been his intent, but he didn't do a very good job of conveying that intent into the language of the bill. So I also received a question at one point, can we vote to keep just some of the provisions of your CC&Rs? You know, let's say maybe you have a prohibition on recreational vehicles on the street and also automobiles, and you want to just continue to enforce recreational vehicles. You know, that's, I don't know. I mean, that's where we're going to have to look through that as well. You know, because again, I'll go back to what I said, that the way the statute is written is it says a meeting and a vote are to be held, I'm paraphrasing there, but it does say on whether to continue to regulate public roadways. So there might be some leeway on how you go about regulating and what we want to keep and what we don't want to keep. You might have that opportunity. And maybe like what Jen said, if it's just about keeping owners off the street and not necessarily guests, then maybe that's the issue. But again, there's a lot of these unanswered questions and things that aren't explained very well by the language in the statute. All right, just quickly on the screen here, there are 4 bills here that we were looking at, and 2 of them we really liked. But just in the interest of time, if you want to take those down, one of the bills has to do with the records request statutes. I believe it's the 1456 Senate bill. There was going to be a proposed change to the record requests, which would have been really good. None of these bills made it to a committee. They died pretty quickly after they were introduced because they didn't get a sponsor. No one sponsored them. But if you want to write those down, go onto the bill tracking website and look them up. You can get an idea of, one has to do with open meetings. One has to do with solar energy and water conservation devices. 1387 was a bill that was an attempt to create additional fiduciary duties on board members. And it was way over the top. And thankfully that one didn't make it very far. So I also mentioned here on the other headstones here that the association's right to foreclose and homestead exemptions, this goes back to that Representative Parker that I mentioned to you before. She's already stated to various individuals that she's coming after associations next year. She plans on targeting associations' rights to foreclose and the homestead exemption that's written into the association lien statutes to make it to where, you know, we're not right now, we don't have to worry about the homestead exemption if you're foreclosing on an assessment lien. Okay, there's going to be an attempt to change that next year. So just be aware of that. Be ready to get involved when you see the calls to action that come out. And like I said, there might be some additional attempts at dealing with parking. Just real quickly, just so you know, there's a couple things going through the courts right now. This Cal versus PFP Dorsey investment is a condo termination case. It was a ruling from the Court of Appeals was issued in favor of the homeowner. The problem with that ruling is it essentially says that, kind of using the Callaway logic from the Callaway CC&R amendment case, that because the issue here for condo termination is the statute. And the court looked at the statute, and that statute for condo termination has changed a couple times over the years. And an argument was made, well, which version of the statute applies? Well, you would think just kind of common sense, well, it'd be the version of the statute on the books right now, right? The Court of Appeals thought differently. And in looking at the Callaway decision said, well, we're going to conclude that the version of the statute in place at the time the person bought her unit is the version of the statute that controls. I mean, it's ridiculous. And because you could think of what this means. Well, how many other statutes in our statutes have changed over the years? Okay, a lot of the statutes have changed. I mean, we talked about some today that have changed. So with this logic, there's an argument out there that says, well, depending on when the owner in your community bought their home, that's the version of the Planned Communities Act that's going to apply to him or to her. That's essentially what this court has said. And so there's an appeal up to the Supreme Court to address a whole bunch of issues. The appeal was filed at the end of September last year. It still has not, right now it's at the stage where the Supreme Court is considering whether to even review it. Okay, there's no briefs yet. It's just the court may look at it and say, okay, we'll review it. And then there's going to be briefs filed and oral arguments. They may say, you know what, we don't want to touch this, get out, Court of Appeals case stands. So we're still waiting for a decision from the Supreme Court on that. I just checked this morning and it's still pending from the Supreme Court. Real quickly, Prop 209, that was the proposition from last year where it changed the garnishment statutes. Right now, wage garnishments are still a thing, but the amount of money that is able to be withheld to pay off judgments has been drastically reduced by that proposition. It was a very misleading proposition that was couched as we're going to save you from medical debt. Just a bunch of lies spewed across the TVs and the radios. It went much further than medical debt, and it really is impacting associations' ability to collect. There is litigation right now. There are multiple cases on appeal challenging the validity of Prop 209, the constitutionality. So kind of wait to see what happens there. And then Cowway, there are some cases where arguments are now starting to be made at the appellate level on the applicability of Cowway. So there might be some cases that come out over the next 6 months or so that deal with the Cowway decision. Now, Jen, your question here, this is great. It says every person who purchases property is on notice that the laws in effect may change. So that exact same argument was made in Cowway, that everyone who buys their unit knows that their CC&Rs have a provision that says these provisions could be amended. The same argument was used to the court in Cowway, and the Cowway looked at it and said, no, we don't care about that. That's not sufficient notice. That same issue came up in this Cow thing. That's not sufficient notice that laws may change. It's what the reasonable expectation was at the time they bought their home. So, I mean, a lot of eye rolling over here when we saw that, a lot of, angry responses about how ridiculous of a decision that is, but that's how the court saw it. And that's where it stands right now. So more to come on that, on that case. So keep an eye out on that. And that's all I have. I know I held you about an hour, so I appreciate those of you sticking around, and my email address is right there. Hopefully you got the chart. If you didn't, please email me or Terry and we'll send it to you. And if you have any questions on what we talked about, don't hesitate to shoot me a quick email, and we can try to talk about it further.